Hi, today I would like to talk about remedies, in particular the remedies in tort law. There is some crossover with remedies in contract law, but there are a few key differences to be aware of. So to start with, I would talk about the aim of remedies in tort law. And the aim is to put the claimant back in the position they were in before the tort happened to them. Now, in some cases, that can be quite straightforward. So, for example, if you've been involved in a car accident and your car needs repairing, what would put you back in the position you were in before the accident happened is the money to get your car repaired. However, there are some more complicated issues. So, for example, there are cases where people have suffered from mesothelioma, which is a type of cancer caused by breathing in asbestos dust. How do you put the claimant back in the position they were in before they had cancer? Or let's imagine someone has been killed in a car accident. How do you put them back in the position they were in before the accident? How do you put their family back in the position they were in? So that's the aim of tort law, but in some cases it can be much more straightforward than others. The key to remember with this is that the aim is not that the claimant will be better or worse off, because remember, none of this is their fault. The key is to put them back in the position so that things are almost returned to the same. Now, that's really going to depend on the types of loss that the claimant has suffered. Some are easier to work out than others. Pecuniary losses are those that are, I would say, easier to work out because they are calculated in monetary terms. They have a price tag, if you like. So, for example, damage to your car would be a pecuniary loss. You can calculate how much it would cost to fix your car by going to a garage. Other damage to property are other types of quite straightforward pecuniary loss. You could also talk about lost wages. So what we would simply do is look at how much you normally earn per hour and how long you've been off for, and that will give you your pecuniary loss. Non-pecuniary losses are more difficult for the courts to work out. These losses still have to be foreseeable to be claimed for, but they don't necessarily have a fixed monetary value. They don't have a price tag. So I've put just a few examples of what you could talk about here. So one, for example, is the pain and suffering you have from an injury. How can we work out how much pain you're in, for example, if you break your leg? Another example is the actual injury himself. So all of our body parts have a price, and the courts will generally use those as a guideline to work out what we're involved. Now, of course, that's a very artificial guideline. You can't go to the shop and buy a new leg, for example, if you've lost yours. But the courts have used a system of precedent to try and work out fairness. So, for example, did you know that women get more than men for facial injuries? Other types of non-pecuniary losses is loss of amenity or amenity. Loss of amenity is the loss of enjoyment of doing something that you used to be able to do. So this can involve things like hobbies. For example, you may be used to like horse riding or dancing, but now you've got a broken leg and can't do those, either permanently or for a short time. It could be that you take part in sport and you can no longer do that, or any other kind of hobbies. But loss of amenity covers much, much more than that. It also covers the ability to do things that you used to do. Driving, housework, even sex would be included in loss of amenity. Now, when we know what type of loss you've suffered, it's then a case of knowing what type of compensation you're going to ask for. What type of damages are you going to get from the court? There are a few types that you need to be aware of in tort law, and the first two are much rarer, but you still need to have an understanding of what they are. The first is nominal damages. Now, nominal means a very small amount, and this is where you're given a token payment to recognise that your rights have been breached. We don't tend to have this as much in tort law, but an example would be the case of trespassing. It might be that someone trespassed on your land, but they've not actually damaged it. There's no need to put you back in the position you were in because nothing's been harmed. However, it is important that we recognise your rights have been infringed, so you might be awarded a token amount, for example £5, and that's just as proof to show that you won your case. The opposite end of the scale, we have aggravated damages. Aggravated damages are often awarded as punishment. Now this again is very rare in tort law because remember, the idea is not to punish the defendant for wrongdoing. We want to move away from blame. Instead, it's remember to put you in the position before the tort happened. Aggravated damages can sometimes be seen in cases against the police, again in trespass to the person, so it might be to act as a deterrent. The main types of damages you need to be aware of are compensatory damages. Compensatory damages are about putting the claimant back in the position before the tort. Compensatory damages can be split into two different categories, and students often confuse these two. And I do think they are confusing because special damages are first, but you tend to think of special damages being, well, special, and so they should come later. I like to remember this as special damages are especially for these certain things. And these things are usually quite easy to identify. Special damages are paid for the expenses the claimant has had to pay out so far. So if you like, they are the things that the claimant has had to suffer between the tort itself happening and the hearing date in court. So for example, if you've been getting hospital treatments but you're no longer able to drive and you've gotten taxis, those would be an example of expenses that you might claim for. You could also claim for things like lost earnings. Now again, those are easy to work out because we would simply look at how long you've been off work, how much are you normally paid in that time period, and that's how much you could claim for. Word of warning, students often talk about medical expenses. Now you have to be careful here because remember, in this country we have the NHS and most of us don't pay for medical expenses. Now an exception might be things like prescriptions. If you normally pay for your prescriptions, that would be an example of special damages that you could claim for. It's a pecuniary loss that would lead to special damages. But in this country, we don't usually pay for operations or doctor's appointments. Now, if you go private, you would only be able to claim for that if you would normally get private treatment. And I'll talk more about that at the end of the video. But generally speaking, you're expected to go to the NHS and you wouldn't have claims. But any bus tickets or taxi fares or parking that you have to pay to get there, any expenses that you've had to pay out because you were in a tort, because you were in an accident, you can claim for. General damages are harder to work out, and I think of these as things that can generally come after. General damages are usually estimated because this is for losses that we anticipate to happen after the hearing. So what we're trying to think is this person suffered perhaps an injury or a loss. What expenses might they have in future that also need to be covered? And again, just to be really clear, these are estimated. So the court is trying to make a projection, but it can't be 100% accurate. Two key examples that you could talk about here are costs of future care. So that could be adaptations. So for example, if you were in an accident and now in a wheelchair, it could be adaptations to your home, so it's wheelchair accessible. It could involve a carer. You may need full-time care. You may have to pay their wages. That's something you could claim for. But again, it could also include future medication. But remember, the same rule applies. If it's treatments that you would get under the NHS that we don't pay for directly, then you can't claim for them as future care. But things like carers or future prescriptions could be. It also includes loss of earnings. Now, loss of earnings in the past are straightforward, but trying to project someone's future loss of earnings is much more complicated. For example, you could argue that you were thinking that you would get a promotion sometime soon or a change of job, and in the near future, you were going to earn more money than you're on now, and that's what you deserve. A-level students are actually a really good example of this. You might have a part-time job at the moment and not earning very much money, and presumably you don't want to earn that amount of money for the rest of your life. If you were paralysed in an accident now, how do we convince the court that you would have perhaps gone to university, you would have studied hard, you would have done well, you would have gotten a good job? How do we convince the judge that you would have been earning more in the future? How would you convince the judge that you would become a high-flying, high-earning barrister? The opposite, of course, is true as well. What if you were probably going to be demoted or even fired in the future? It could be actually that you would be on less money than you were at the point of the accident. So this can be very, very complicated, and the courts have worked out calculations, but this is really where people get those large sums of compensation. For example, in the case of Montgomery versus Lanarkshire Health Board, the baby was born with disabilities, which meant they probably would never be able to work. So they are going to need loss of earnings that would cover their whole working life, which, would be 40 or 50 years. That's why we can get large sums of money when it comes to compensation claims. Now, how are those paid? Now, I can't stress this enough. Damages are normally paid in one single one-off lump sum. So the judges, the courts will talk about all of these compensatory losses, all of the damages you get for those. They'll work them out to a price, and that's how much you'll be given by the defendant. Now, there are certain situations where under the Damages Act 1996, so quite a new law actually, you might be entitled to a structured settlement. Now, what that means is you get the same amount of money, but it's split into periodic payments, kind of monthly or yearly sums, a bit like a wage or a salary. Now, these are usually in cases of prolonged harm. Remember Montgomery? I said that baby would essentially never be able to work as an adult. Rather than giving them £15 million an hour, for example, it might be that that is paid yearly to them to provide almost a replacement salary. I can't stress enough that that is in very, very unusual circumstances where you've normally got a long-term illness. Sometimes students talk about periodic payments where they see time periods in an exam question. So for example, there was a past exam question where someone had injured their leg and it was thought they'd be off work for 6 weeks. And people were talking about a periodic payment, a payment per week. That wouldn't happen in reality. That would be a single one-off lump sum, and then it's up to the claimant how to manage that money themselves. I'd probably spend it all at once, but you're supposed to ration it out yourself. Periodic payments, those structured settlements, offer large sums of money where someone is perhaps paralysed or, they need that money over a long, long period of time. So these are very, very rare in civil law. The last thing that you would talk about, and this is really, really essential if you're aiming for those high grades, is mitigation of losses. Now, mitigation of losses sounds scary, but it's actually quite straightforward. It's the idea that the claimant also has to take some responsibility faced with the tort, and they have a responsibility to mitigate any suffering they have. Now, mitigating is just a fancy legal term for minimising. So you're expected to do your part to keep your costs low as well. So remember before I kind of talked about medical treatment, you can't just go private because someone else is paying. If your car's damaged and you need to get a replacement hire car, you're expected to go for something similar to what you were already driving. You can't just go for like a super fast, super expensive Ferrari because someone else is paying for the bill. You have to take your own responsibility. So for example, if the doctor tells you to rest your leg, you're expected to do that to reduce the amount of recovery time. If you don't rest your leg and you end up being iller for longer, you can't claim for that extra period. You are expected to do your own part to make sure your own losses are reduced, to keep those costs down. Because remember, the aim of tort law is to put you back in the position you were in before the tort. You shouldn't be better off because of that. You shouldn't be now driving a Ferrari. You shouldn't be worse off either. So I know sometimes it can sound really silly, the idea of claiming for bus tickets or parking charges, but why should you pay for any of those things when you weren't responsible in the first place? It's not usually about punishing the defendant unless it's aggravated damages. It's simply about acknowledging that something's happened to this person that shouldn't have. How do we try and return things to normal as much as we possibly can? Thank you for listening.